Losing a loved one is one of the most difficult experiences we face. In the midst of profound grief, a massive responsibility often lands on the shoulders of one person, the executor. You might be stepping into those shoes right now, feeling completely overwhelmed. Being named an executor, or an administrator if there is no will, is a final act of trust, but it is also a complex legal and financial job. You are tasked with closing out a life's worth of administrative details. The paperwork, legal jargon, and family dynamics can make this journey feel impossible, but it does not have to be. In this guide, we will walk you through the essential steps of managing a deceased estate, giving you the clarity needed to honor your loved one's legacy. Managing a deceased loved one's estate is a profound responsibility, but who actually steps into this role? The duty typically falls to either an executor or an administrator. While often used interchangeably, there is a clear legal distinction between the two. An executor is a person explicitly named in the deceased individual's last will and testament. Being appointed means the deceased specifically trusted you to carry out their final wishes, settle debts, and distribute assets exactly as detailed in their will. But what if someone dies without a will? In this situation, the probate court steps in to appoint an administrator, typically a close family member. An administrator has the same responsibilities as an executor, but distributes the estate according to state laws rather than a will. Whether you serve as an executor or an administrator, your core obligation is identical. You are bound by a fiduciary duty to the estate and its beneficiaries. This means acting with absolute good faith, total transparency, and prioritizing the estate's best interests above your own at all times. The first 30 days after a loved one passes are often the most overwhelming, but as an executor, taking immediate, organized action is crucial. Your very first step is locating the most recent, original last will and testament. This document is your roadmap. Read it thoroughly to understand any immediate funeral wishes and to confirm your official appointment as the executor. Once the will is in hand, your next critical task is obtaining multiple certified copies of the death certificate. You will typically need anywhere from 10 to 20 copies, as almost every financial institution, government agency, and life insurance company will require an original certified copy to process claims or freeze accounts. During this time, you must also begin the sensitive process of identifying and notifying the beneficiaries named in the will, keeping detailed notes of every phone call and correspondence you make. Simultaneously, it is your legal duty to secure and protect the deceased's physical assets. Start by changing the locks on their primary residence to prevent unauthorized access, even from well-meaning family members. Secure any valuable personal property, such as jewelry or important legal documents, in a modern digital safe or a safety deposit box. Finally, arrange to forward or carefully retrieve their mail, as this will help you discover hidden assets or outstanding debts. These immediate steps protect the estate and set a solid foundation for the legal process ahead. Once the initial legal hurdles are cleared, your role shifts to the core of estate administration. As an executor, you are bound by fiduciary duty, meaning you must manage the estate with the utmost care and loyalty. Your first major task is compiling a comprehensive inventory and determining the date of death valuation for all estate assets, from bank accounts and real estate to personal belongings. With the assets identified, you must address the estate's liabilities. This involves notifying known creditors, reviewing claims, and paying legitimate debts out of the estate accounts, including final medical bills and funeral expenses. It is crucial to follow the strict legal order of priority for payments to avoid any personal liability. The deceased's financial portfolio also requires your immediate attention. You are responsible for managing existing investments while the estate is settled. This might involve working with a financial advisor to safeguard assets against market fluctuations and making prudent decisions to preserve the estate's overall value. In some cases, you may need to liquidate assets. This frequently involves preparing and selling real estate to cover outstanding debts or to distribute the proceeds evenly among the heirs. Finally, before any inheritances can be paid out, you must ensure all final income and estate taxes are accurately filed and paid to the IRS and state authorities. This tax phase is meticulous, but absolutely essential. After all debts are paid and taxes are settled, the executor arrives at the final, most anticipated stage, distributing the assets. This is where the deceased's wishes, as outlined in their will, are finally realized. If there was no will, the assets are distributed according to the state's intestate succession laws. But before handing over the keys and the checks, there is a crucial step, the final accounting. The executor must provide a detailed report to all beneficiaries and the court, showing exactly how the estate's funds were managed, what was paid out, and what remains. Transparency here is key to preventing any last-minute disputes among family members. Once the accounting is approved, the actual distribution takes place. Beneficiaries receive their inheritances, signing receipts to acknowledge what they have been given. It is a moment of closure for the family, often bringing a sense of relief and finalized transition as the tangible pieces of a legacy are passed on. The final official act is returning to the probate court. The executor submits the final accounting, the receipts from beneficiaries, and requests a formal discharge. Once the court approves and the final documents are stamped, the estate is officially closed, and the executor's journey is complete, leaving behind a legacy settled and honored. Serving as an executor is more than just a strict administrative duty. It is a profound emotional journey that is often heavily clouded by personal grief, as well as a series of highly complex legal responsibilities that demand your full attention. As you manage the estate, you might encounter significant and unexpected hurdles along the way. These challenges can range from simmering family disputes over sentimental items and inheritance to discovering hidden financial debts or even untangling complicated international assets that require specialized knowledge. Navigating this intricate maze alone can quickly become overwhelming, which is why seeking out professional help is invaluable. Experienced estate attorneys and financial advisors can provide the vital clarity and legal protection you need to proceed safely. Additionally, when emotional tensions run high, do not hesitate to involve neutral third parties, like mediators or family counselors. Fostering open communication and relying on professional guidance can truly help preserve delicate family relationships during this difficult life transition. Taking on the role of an executor or administrator is an act of profound love and responsibility. It is a heavy burden, especially when you are navigating your own grief, but the work you are doing is incredibly important for honoring your loved one's legacy. We want to take a moment to genuinely thank you for stepping up during such a difficult time. You do not have to walk this path alone. For more detailed guides, checklists, and a community of support to help you through every step of managing a deceased estate, please visit funeralists.com. Our resources are designed to bring you clarity and peace of mind when you need it most. If you found this video helpful, please give it a thumbs up. Subscribe to our channel for more guidance, and leave any questions or your own experiences in the comments below. Take care of yourself, and thank you for watching.